What's up, gang? Welcome back to the channel. We got a little bit of breaking news here for you this morning. I have the complaint. If you haven't seen it on Twitter or wherever already, Amber has been sued by the insurance company that was supposed to be taking care of her legal fees and all kinds of stuff. They don't want to pay for her stuff because she lost. The jury found that she acted with malice and did this to herself. And these guys were covering her for up to $1 million in liability, but now they're saying they don't want to pay. So I have the complaint here, and I haven't read it yet. It's about 11 pages long, and we're just going to go through it together. So, United States District Court, Central District of California, Western Division, New York Marine and General Insurance Company, New York Corporation, plaintiff versus Amber Heard, the defendant. Complaint for declaratory relief and demand for a jury trial. Plaintiff, New York Marine and General Insurance Company, allege as follows: jurisdiction and venue. United States District Court for the Central District of California has original jurisdiction over this case. They're citing a bunch of stuff. The amount in controversy exceeds the sum of $75,000, and this matter involves citizens of different states. This court is authorized to grant declaratory judgment under the Declaratory Judgment Act pursuant to Rule 57. New York Marine seeks a judicial determination of the respective rights of the parties under an insurance policy issued to Under the Black Sky, Inc., which included Amber Heard as a named insured with respect to Heard's defense and indemnity in an underlying lawsuit. Plaintiff's claims for declaratory relief are authorized. Venue is proper. Plaintiff, New York Marine, is a corporation organized under the laws of the state of New York. Heard is, and at all times herein mentioned, was an individual who is a citizen and resident of California. Here's the insurance policy. New York Marine issued insurance policy number, all that, to named insureds Under the Black Sky, Inc. and Amber Heard for the policy period July 18th, 2018 to July 18th, 2019, with a per occurrence limit of liability of $1 million here and after the policy. A true and correct copy of the policy with premium and address information redacted is attached as Exhibit A. Policy includes a comprehensive personal liability coverage part, which provides coverage for damages because of bodily injury, property damage, or personal injury caused by an occurrence to which the coverage applies. Policy defines personal injury to mean injury to other than bodily injury arising out of one or more enumerated offenses included in the policy, which includes oral or written publication of material that slanders or libels a person or organization, including other forms of defamation, and oral or written publication of material, including other forms of defamation that violates a person's right of privacy. The underlying lawsuit. On March 1st, 2019, Johnny filed a lawsuit against Heard in the Circuit Court of Fairfax County. In the underlying action, Depp sought and is seeking damages for defamation based on the op-ed written by Heard and published in the Washington Post. A true and correct copy of the complaint is attached as Exhibit B. On or about September 4th, 2019, Heard tendered the underlying action to New York Marine. On October 1st, 2019, New York Marine accepted Heard's defense of the underlying action subject to reservation of rights. Specifically, New York Marine advised Heard that New York Marine would provide a legal defense, but that to the extent California law does not permit an insurer to indemnify the insured, no indemnity can be provided. At the time Heard tendered the underlying action, the law firm Cameron McAvoy PLLC was defending Heard in the underlying action. When New York Marine accepted Heard's defense, New York Marine agreed to continue the defense of Heard through the law firm Cameron McAvoy PLLC. New York Marine is informed and believes, and on such information and brief alleges that Heard or her agents instructed other firms defending Heard in the underlying action to not include Cameron McAvoy in Heard's ongoing defense. As a result, on or around November 2nd, 2020, Cameron McAvoy withdrew from the defense of Heard in the underlying action. The underlying action proceeded to trial beginning April 11th, 2022. On May 27th, 2022, the court in the underlying action issued jury instructions to the jury. A true and correct copy of the jury instructions are attached as Exhibit C. In the jury instructions, the court in the underlying action instructed the jury that with respect to liability issues for Depp's claims against Heard, the jury's verdict must be based on the facts as you find them and on the law contained in all of these instructions. The jury instructions also instructed the jury that with respect to liability issues for Depp's claims against Heard, the issues for the jury to decide were whether Ms. Heard made or published any of the following statements. Amber Heard, I spoke up against as violence and faced our culture's wrath. That has to change. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. I had the rare vantage point of seeing in real time how institutions protect men accused of abuse. As a finding instruction, the court in the underlying action instructed the jury that it shall only return your verdict for Mr. Depp on his claim for defamation if Depp proved by the greater weight of evidence that, one, Ms. Heard made or published the following statement. Then 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. And two, the statement was about Mr. Depp. And three, the statement is false. And four, the statement has a defamatory implication about Mr. Depp. And five, the defamatory implication was designed and intended by Ms. Heard. And six, due to the circumstances surrounding the publication of the statement, it conveyed a defamatory implication to someone who saw it other than Mr. Depp. And if Mr. Depp further proved by clear and convincing evidence that, number seven, Ms. Heard made the statement with actual malice. If Mr. Depp failed to prove any one or more of the 7 elements above, then you shall find your verdict for Ms. Heard with respect to the above statement. The court in the underlying action issued a nearly identical finding instruction for each of the 2 other statements identified in paragraph 20 above, which only changed the content of the first element to replace the statement at issue. On June 1st, 2022, the jury in the underlying action returned a verdict in favor of Depp for counts of defamation based on all 3 statements. This verdict was incorporated into a judgment order, which was entered by the court in the underlying action on June 24th, 2022. A true and correct copy of the judgment order is attached hereto as Exhibit D. As detailed in the special verdict form, with regard to each of the 3 statements at issue, the jury found that Depp had proven all the elements of defamation and answered in the affirmative to all of the following questions. Statement was made or published by Ms. Heard. Statement was about Mr. Depp. Statement was false. The statement had a defamatory implication about Mr. Depp. Defamatory implication was designed and intended by Ms. Heard due to circumstances surrounding the publication of the statement and conveyed a defamatory implication to someone who saw it other than Mr. Depp. After answering all of those questions, yes, the jury also answered yes to the question, do you find that Mr. Depp has proven by clear and convincing evidence that Ms. Heard acted with actual malice? The jury awarded Depp $10 million in compensatory damages and $5 million in punitive damages from Ms. Heard. However, the punitive damages were reduced to a statutory cap of $350,000 pursuant to Virginia Code. First cause of action. Declaratory relief as to plaintiff's duty to indemnify Ms. Heard for the judgment order under the policy. Plaintiff incorporates by reference all of the allegations of paragraph 1 through 26, though fully set forth herein. California Insurance Code 533 provides that an insurer is not liable for a loss caused by the willful act of the insured, but he is not exonerated by the negligence of the insured or of the insured's agents or others. This provision is an implied exclusionary clause by statute and is read into all insurance policies under California law. The jury's factual findings establish that Heard's liability is caused by the willful acts of Heard. As a result, as a matter of California public policy and pursuant to California Insurance Code 533, the policy does not provide coverage for Heard's liability as reflected in the judgment order entered on June 24th, 2022. An actual controversy has arisen and now exists between plaintiff on the one hand and Heard on the other hand. With regard to the duties and obligations owed between plaintiff and Heard under the policy with respect to the judgment order, plaintiff contends that it has no duty to indemnify Heard for the judgment order entered on June 24th, 2022. Plaintiff is informed and believes, and on such information and belief, alleges that Heard disputes plaintiff's contention and asserts that the policy provides indemnity coverage for Heard for the judgment order entered on June 24th, 2022. Due to the actual and present controversy described above, pursuant to 28 U.S.C. 2201, plaintiff requests a judicial declaration of rights, duties, and obligations under the policy, determining that if said judgment order entered on June 24th becomes final on appeal or otherwise, plaintiff has no obligation to indemnify Heard for the judgment order. Second cause of action. Declaratory relief as to plaintiff's duty to indemnify Heard for any judgment in the underlying action. Plaintiff incorporates by reference all of the allegations of paragraphs 1 through 31, though fully set forth herein. California Insurance Code 533 provides that an insurer is not liable for a loss caused by the willful act of the insured. He is not exonerated by the negligence of the insured or of the insurance agents or others. This provision is an implied exclusionary cause, which by statute is read into all insurance policies under California law. As a matter of California public policy and pursuant to California's Insurance Code 533, the policy does not provide coverage for Heard's liability to debt. An actual controversy has arisen, now exists between plaintiff on the one hand, Heard on the other, with regard to duties and obligations owed between plaintiff and Heard under the policy with respect to indemnity for the underlying action. Plaintiff contends that it has no duty to indemnify Heard for the underlying action. Plaintiff is informed and believes, and on such information and belief alleges that Heard disputes plaintiff's contention and asserts that the policy provides indemnity coverage for her and any liability which may be established in the underlying action. Due to the actual present controversy described above, pursuant to 28 U.S.C. 2201, plaintiff requests a judicial declaration of the rights, duties, and obligations under the policy, determining that plaintiff has no obligation to indemnify Heard for any liability regarding the underlying action. Third cause of action. Plaintiff incorporates by reference all of the allegations of paragraphs 1 through 36, though fully set forth herein. Because the jury's factual findings regarding Heard's liability to debt required a finding of willful acts by Heard to establish liability, California public policy and California Insurance Code 533 preclude New York Marine from having any obligation to defend Heard in the underlying action. An actual controversy has arisen and now exists between plaintiffs on the one hand and Heard on the other with regard to the duties and obligations owed between plaintiff and Heard on the policy. Plaintiff contends that it has no duty to defend Heard based on California Insurance Code 533. Plaintiff is informed and believes on such information belief alleges that Heard disputes plaintiff's contentions and asserts that the policy obligates New York Marine to continue to defend Heard on an ongoing basis in the underlying action. Plaintiff requests a judicial declaration of rights, duties, obligations under the policy, determining that with respect to defense of Heard, plaintiff has no obligation on an ongoing basis for the underlying action. Fourth cause of action. The comprehensive personal liability coverage part of the policy provides under conditions, duties after losses, that Heard must help New York Marine by seeing that the enumerated duties are performed, including helping New York Marine with the conduct of suits and attend hearings and trials. New York Marine is informed and believed, and on such information and belief alleges that after New York Marine accepted Heard's defense, Heard both individually and through her agents refused to help New York Marine with the conduct of the suit and instructed other defense firms representing Heard not to include defense counsel provided by New York Marine in the ongoing defense of Heard in the underlying action. Interesting. All right, this all says the same stuff. Prayer for relief. Enter a judgment declaring that plaintiff has no duty to indemnify Heard for the judgment order entered on June 24th, 2022 in the Circuit Court of Fairfax County, Virginia. Plaintiff has no duty to indemnify Heard for any liability in the Circuit Court of Fairfax. Plaintiff has no duty to defend Heard on an ongoing basis in the underlying action. Circuit Court of Fairfax, case number, all that, or in connection with any appeal of the judgment in the underlying action. Award New York Marine its costs and grant such further relief as this court deems just and proper. Dated July 8th, 2022. Defendant and counterclaimant, New York Marine, hereby demands a jury trial to the full extent facilitated by the law. So that's it. I'm sure the legal eagles will take this into consideration and do a much better job of explaining it. So here it is for you guys, and I'm sure they'll be able to tear this apart for you guys, but it is very interesting. She got sued by an insurance company. What a great Saturday. All right, y'all, have a great weekend, and I will see you next time.